Hi, my name is attorney Stacy Shaw, and this is Stacy Shaw Knows the Law. So today we're going over ex parte orders. What to do if you get served with an ex parte order of protection in the state of Missouri. Ex parte means without one of the parties. And so to get an ex parte, a person does not need to present a lot of evidence to get an ex parte order because it's temporary and it's in place until there can be a hearing on the matter. If you get served with an ex parte motion, there is going to be a court date that is listed on the paperwork that you're served by the sheriff. This is super important because that is going to be your opportunity to present evidence if you are contesting the ex parte order. If you do not show up, then the ex parte order will be issued against you with a finding of a threat of force. This is super important because it restricts your ability to carry a firearm. So some people say, it's no big deal, I'm just going to let whatever happen, but it's super important that you actually take care of it. So when you do go to the hearing, you're going to have three options. Option number one, you can consent to the ex parte order, making it a full order of protection for a year, but there will not be a finding of a threat of violence. This will allow you to keep your firearm privileges intact. And if you are going through a custody matter or some other legal action, they cannot use the findings of being a stalker or having a threat of violence or having any negative connotation associated with that order of protection, because remember, it's ex parte, so there's only allegations against you, so there's no finding that those allegations were in fact true. The second thing that you can do is that you can ask for a continuance to get an attorney to go to trial. I always suggest doing this, okay? So if you are not sure about the proceeding, always ask for a continuance to have an opportunity to seek legal counsel. After you seek legal counsel, you will get have the opportunity for them to represent you in the trial if you want to. So the third option is you going to trial either by yourself or with an attorney. It's super important if you are going to trial by yourself that you're really prepared. Okay, that means that you have to have your evidence in place. So just showing pictures of your phone is not going to be enough. There's going to have to be printed out text messages or pictures or something physical that the court can enter in as evidence. Your testimony is also going to be evidence. So make sure that you are prepared to not only say your side of the story, but also ask questions of any witnesses. If you have an attorney, make sure that you give them all of the evidence that you want to present on your behalf, because it's kind of like a all or nothing type of deal. You are going to want to make sure that you can disprove as many of the allegations as possible in that hearing. If you are successful in the hearing, that means that a full order of protection will not be entered against you. This means that everything just goes away. There will not be an order of protection, and basically the matter is closed. If you are found guilty or that the allegations against you are credible and you do pose a threat to the other person, then a full order of protection will be entered against you, and you will not be able to possess, carry, or use firearms for the duration of the order of protection. This is super important because if you are found that you are a threat to the other person, then if you do violate that order of protection, you could be criminally liable, and it's a very serious offense, violating an order of protection. If you have questions, you can always give us a call at 816-359-1877. You can find us on all social media at Stacy Shaw Law, and you can find us online at stacyshawlaw.com.